Good evening, everyone. Welcome to the special immigration show brought to you by Sakshi TV. My name is Ranjit. We are here today with the prominent attorney, Ms. Sheela Murthy, to discuss the latest updates on immigration and also about the H1B registration process. You can call the numbers displayed on the screen and ask any question related to immigration, and the attorney will be glad to answer. We'll start taking calls in a few minutes. Before starting the show, I would like to repeat the disclaimer. Please note this show does not provide any legal advice and it is general in nature, and it is only for informational purposes. Case-specific questions must be routed to the attorney. Please reach out to attorney if you have case-specific questions. Sakshi TV news and agents are not responsible in any way for your actions. Please use the information at your own risk. Hi, Ms. Muthi, how are you?
Good. How are you doing, Ranjit? Great to be here and welcome everybody.
Yeah, you all know very well about Ms. Muthi. She's the founder and president of Murthy Law Firm and Harvard Law School graduate. And she's the one behind the famous Murthy.com website. Before getting into session, we'll let Ms. Murthy introduce and then we'll take it from there.
Thank you so much, Ranjit. Thank you, everybody. So what can I say, Ranjit, besides Murthy.com? As I often say, our goal is to educate, enlighten, and empower immigrants going through the complex, difficult, and stressful journey of U.S. immigration law. So please take advantage of the free Murthy Bulletin, which is a weekly bulletin, the free Murthy Forum, which has over 150,000 or 200,000, which means 1.5 lakhs or 2 lakhs people signing up and asking, with lawyers answering a lot of the questions and guiding the discussion, as well as, of course, the latest teleconferences that we do through various organizations. Last night, there was a She Jobs keynote in Dallas, Texas, that I was participating virtually, of course. And with IT Serve Alliance, Maryland Institute College of Art, lots and lots of discussions on the hot topics on immigration, on keynotes, on leadership. Just how can we support, empower, and take care of each other as immigrants who have walked the journey, maybe just a few years before many of you. So thank you for joining us today, and thank you, Ranjit.
Before getting into the our topic, could you please let us know the latest update? We are just hearing news that public charge rule has been dismissed. Could you please explain about it, and then we'll take the calls. We have a lot of calls.
Yes, in fact, CNN has just released the news a couple of minutes ago, and it's basically where the Supreme Court has agreed to dismiss the public charge rule. As many of you will remember, the public charge rule was dismissed last year based on multiple lawsuits. Then it came back again. It was several circuit courts said it was improper, illegal. The president had exceeded the authority under the laws and the Constitution. So it was on hold. And then finally, last was that it was reinstated. So all the 485 adjustment of status, family-based cases, consular visa appointments, all were using this very complicated 18-page form if you're in the United States to complete, with so much underlying documentation. It's driving people crazy. But now, today, just now, a few minutes ago, the Supreme Court, based on a legal challenge by the Legal Aid Society and several other organizations, and because the Biden administration also obviously changed its position, they said, we're not interested in fighting to continue with this rule. So when both sides of the equation are saying, we're not interested in pursuing or continuing with the public charge rule, the Supreme Court said, well, then the rule is now off the table, and they agreed to dismiss it. So all adjustment of status cases that are being filed from today onwards, or from tomorrow onwards, presumably, that will reach USCIS, no longer need to hopefully complete the onerous and burdensome paperwork and forms and documentation and proof of your bank accounts, your assets, it's just so much work that it was really, really adding a lot of time, effort, energy, and stress. And many cases were actually being rejected by USCIS because people were not including the public charge documents and the extra paperwork required. Also, US consulates abroad, for people who are applying for the immigrant visas, they were looking at a much more burdensome rule than a much simpler rule that was under the former 864 affidavit of support, which is a much, much simpler form where the relative who is sponsoring you shows that they can financially afford to sponsor you, or you can show that. So presumably that's going to come back now, Ranjit.
That sounds good. That I hope this saves a lot of time for the beneficiaries as well as attorneys. We have a caller, Naga from New Jersey. Let's take the call. Hi, Naga. Welcome to the show. Please go ahead and ask your question.
Hi, ma'am. Good afternoon.
Hi, Naga.
Thank you for your time and educating us on immigration. My question is, I was with employer A almost for 7 years, and my prior date was September 2015. And I had H1B approval extension with employer A that was approved until September 2023. In October 2020, I moved to employer B. My question is, if priority date moves and my priority date becomes current in October 2021, can I go back to employer A and file for 485?
Sure. If employer A has a job for you, Naga, and they offer the job a permanent full-time position as required under the PERM and the I-140 petition, then, and you agree to go back and they offer you the job and you promise to stay on a permanent full-time basis after your green card is approved to work with them, then absolutely you can go back, file the 485 because you have the PERM and I-140 approved with them. Hopefully right now, in the meanwhile, company A has not withdrawn or revoked the I-140 petition for you, because if they revoke it, then they would have to refile a new I-140 petition using that old PERM labor certification, because many employers are doing the I-140 withdrawals or requesting USCIS to revoke the approval. But if nothing has happened, if the prior employer has left everything as it is, then you can absolutely plan to go back as long as you work with them and they offer you the job, and then you can file the 485 through that original employer with whom you have the PERM and I-140 approval, Naga.
Okay, ma'am. The follow-up question, if I want to go back to employer A, do I need to do H1B transfer again? Or can I go back to existing H1B with them? I have H1B approval with them until September 2023.
So again, Naga, it depends on whether the H1 petition was revoked or it continues to remain valid and they decided not to request the USCIS to revoke the prior H1
employer
petition.
told me that, employer A told me that they won't revoke my H1B or I-140.
Okay, so that is unusual. The I-140, many employers do not revoke, but by law, actually, the USCIS requires the employer and the Department of Labor requires the employer, when an employee quits, leaves, or is terminated, to cancel, revoke, or withdraw the LCA and the H1 petition. Sometimes employers will keep it like this for 3 months, 6 months, up to a year, but it's risky from the employer's perspective. But if they have confirmed that with you and it has not been revoked, then absolutely make 100% sure of that. Check on the USCIS website. Naga, check with the employer and the employee's attorney that nobody by mistake or inadvertently, without realizing that the employer had promised you that they won't withdraw it, that by mistake nobody had withdrawn or revoked it. And if it is still valid and the I-140 is valid, then absolutely you can continue with the process of your green card and continue on that same prior H1B according to some USCIS memos that have been out there from decades and decades ago, Naga.
But I was told that, actually one of my friends told that since, the I-94 with employer A and employer B H1Bs both are same. So since employer B H1B is approved, the employer A H1B will be like invalid. Is that true, ma'am?
So again, as I said, this is based on, this is not in the statute, the law, even in the regulations, or even written clear-cut guidance from USCIS, Naga. So what the new employer B, needs to do is revoke their H1 petition, stating that it is our understanding that the employee has returned back to the prior employer, and we therefore wish to revoke it since he has left our employment. So then there is no same I-94 card H1 approval with company B valid any longer. If employer B revokes it, then the employer A H1 petition should be the only one with that I-94 card number that is still valid and not revoked with your name as the beneficiary.
Thanks, Naga. Thanks for the call. We have a lot of calls waiting. Meanwhile, we'll talk about the H1B registration and lottery that's just started today, I believe. Could you please just give an overview of it and the main things employees and employers have to keep in mind?
Sure. So as most of you are aware, the registration system started at 12 noon Eastern time on Tuesday, March the 9th, and it continues until 12 noon Eastern time on March 25th. This is different than last year when it started on March 1st. The USCIS has confirmed that they will notify all people who have been selected under the pre-registration system before March 31st, so that the employer is able to file the H1B petition within 90 days during April, May, and June. And the USCIS has also said that if during the middle they realize that there are not enough people that have filed by June, they can then decide to again pick the additional numbers or additional cases under the lottery system for the pre-registration, and which is what we saw last year, that I think Murthy Law Firm got quite a few, 30 or 40 cases again afterwards that we had to process for H1 petitions that were not selected in the first go around. Because the USCIS felt, because of COVID-19, that many employers did not file as many H1 petitions as they had originally planned to do. So unlike in prior years, you don't have to, as the employer, prepare the entire package beforehand. Only those who are selected have to file the H1 petition. Again, the complex rules apply to gap. If you're on a student with F1 status, if you're selected in the registration, it means nothing. Your employer has to actually file the petition for you in order for you to enjoy the gap benefits to legal ability to stay legally and continue to work based on the F1 OPT or the STEM OPT. That's a big deal for many individuals, especially F1 OPT students, who need that gap protection to keep working, but it's the filing of the petition with USCIS and not simply getting selected under the lottery that will protect you and give you valid legal status to stay and work in the United States. There are lots of other nuances about the H1B registration system that we can go through either in questions and answers or if people have additional, clarifications.
Yeah, that was a great explanation, Ms. Murthy. Now, I would like to know what are the complications we have, especially now the registration process doesn't have a work location. What if the employers are, the beneficiaries want to use this loophole and file multiple H1Bs because there is no work location here? Same can be filed by multiple, let's say the vendor, maybe the client, and also someone else. How USCIS will be able to identify it, because there is no way the work location. So how will they identify it's a singular duplicate?
Yeah, the USCIS looks at the employer/petitioner and employee/beneficiary. They are not looking at the actual work location as mentioned in any of the documents. So if there's more than one petition filed by the same employer, or even using the same set of contracts by a completely different employer with a different federal employer identification number or tax ID number, the USCIS has said that is not legally possible. In fact, all petitions filed for that beneficiary by that employer then will be canceled. So I would not absolutely recommend anybody as an employer or an employee allowing or asking the employer to file more than one petition for one employer, one employee. And even if it's a completely different employer, if it's the same underlying project, it could be a problem. Now, you're saying what happens because it's not in the same location, but that doesn't matter. It's not the location that they're looking at. It's the name of the entities and the federal employer ID number that would trigger the red flag and jeopardize and make it very risky of getting everything canceled. And we have seen a couple of times where people thought that the first case was not received by USCIS for a long time, for 90 days or 60 days. Maybe USCIS misplaced the package. The person filed a second H1, and then USCIS approved the first one, realized that their person had filed a second case, and they revoked both. And there was a lot of back and forth. It was very stressful. So we tell people, please don't try to work or scam the system. Don't try to take shortcuts because it's not worth it.
True, true. That's what I was talking about, because even people say it's a gray area, and a lot of people want to, cut the corners, but that could eventually hurt other people and the system. That's what is very important, to keep the integrity of the system. So yeah, another follow-up question: what happens? Let's say an employer filed a petition, but then it's picked in the lottery. Ms. Murthy, we are talking about what happens. Let's say, especially the big companies have a project where there are multiple resources requirements. So now there is only just registration. Let's say the employer just want to file like multiple petitions, and once they picked in the lottery, what if they don't file after getting picked in the lottery? Are there any complications and implications from the USCIS for not filing the H1B after picking in the lottery?
So when the employer / petitioner files the pre-registration, it requires and says, I, the employer, intend and agree that I plan to file the H1B petition on behalf of my this beneficiary employee, with whatever details they gave, with the name, the passport number, date of birth, etc. Now, obviously, if the financial situation changes, life happens, companies are going through major crisis financially because of COVID-19 or other factors outside of their control, the employer by law is not saying that if I don't do it, I'm exposing myself to some type of serious violation under the law. It's just an intention legally that, all things remaining the same, I have every intention of filing for this employee. But let's say the employee, something happens in their family and they have to return back to their home country, India, or wherever the person needs to go. Then how can the employer file and waste thousands of dollars in legal fees for something that the employee may say, I'm sorry, I'm not available because of my family situation to work in the United States any longer. Or the employer has financial situations or problems, or loses a very, very big contract that they had planned to put this person in. Right now, as far as we know, it's just a good faith intention on the part of the parties to process the H1 petition, for the employer to file it, the employee to work in that position, but it is not a legal mandatory requirement with severe legal consequences either to the employer or to the employee.
Okay, so you mean to say that as a good faith, every employer should only file if it's required and not just do it. If there is a let's say the real issue and they are not able to file, that's fine, but they just can't do it, like just file it and just leave it like that.
Well, the whole idea in everything in life, most of life is all about good faith, right? I mean, if you and I have this discussion that we're planning to have this call every day, every week, if I don't show up or you don't show up, it's not good. 99% of the world works without a legal document. And here the USCIS has had the parties sign a legal document saying that we have a good faith intention to pursue the filing of the H1 petition. So I would not recommend that either the employer or the employee act very flippant and casual, because you are saying that all parties intend to continue with the H1 processing, the employer to process and file the case, and the employee agrees to work for that employer when that petition is filed and approved. So yes, in general, I do not like people signing under oath or agreeing to do something, even verbally, let alone in writing, and then completely reneging, because then that's when we lose credibility and the integrity and honesty of the entire system, in fact, of entire society, I think is impacted when people don't do what they say that we will do.
True. Another burning question is, a lot of people, everyone knows, but still they ignore the fact that it is illegal to pay for the H1B by an employee. What do you, say? There are a lot of scammers out there as well who just try to, get money out of misery. You know it very well. So what is your take on this, and what do you strictly advise the employees and employers what to do and what not to do?
So the US Department of Labor, as most of us are aware, takes the position that all of the legal fees and processing fees, whether it's attorney fees, the anti-fraud fee, the training fee, pretty much most of the legal fees associated with an H1B petition processing should be the responsibility of the employer to incur and should not be taken back from the employee. Some employers say, okay, whatever is crystal clear, like the training fee, the fraud fee, that I won't take from you. There's a little bit of gray area because USCIS has not been as crystal clear as US Department of Labor. And so some people take the legal fees and filing fees for the family members, the spouse and children, if they are abroad or if they're in the United States, and their change of status fees. That's, I think, more of a gray area. And it's not as crystal clear in terms of black and white violations of the law. Also, the employer cannot take back the legal fees and the processing fees from the employee if the net result of getting that reimbursement reduces the salary of the H1B employee, so that the prevailing wage for the H1 is no longer being paid to that worker. Because by law, the Department of Labor requires the employer to pay, as we all know, the higher of the actual wage or the prevailing wage. But when the employer takes fees back, if that results in the prevailing wage or the actual wage dropping, then it's a violation. And that could incur and result in problems for both the employer for violating H1B laws and regulations and the employee, because it's a failure to maintain status when the employee isn't getting paid the full proper wage as mentioned by the US Department of Labor on the LCA.
Got it. Thanks for clarifying. And yeah, please be on the lookout, as Ms. Murthy was saying, if some company is asking for your money, you should be aware that it's not a genuine. The follow-up question here is, we were talking about the cap gap. When we are talking about the cap gap, could you please explain what cap gap is, and is it automatically availed, or you have to apply to get a cap gap, and what is the validity of the cap gap? If you could explain, it would be helpful for a lot of students.
Wonderful. Yes, absolutely. It's a fairly, it was one of the changes that was introduced when they introduced the DHS STEM rule, offering this additional 2 years of the STEM OPT extension for students in science, technology, engineering, or math. And it's now available even during for the 1 year regular STEM, the regular F1 12 months optional practical training. So for example, let's say that most students graduate around May or June every year when they finish their master's or bachelor's degree. So let's say you've completed your master's degree in June and you file your F1 OPT. And I know nowadays it takes USCIS several months to approve the case, but let's say like in the olden days, they approved it within, a few weeks. So you get it you apply end of May or early June, you get it by end of June. Now your employer, so you'll get it for 12 months, the F1 OPT till the following year, June. But your H1B is selected in the pre-registration. Your employer submits the H1B petition with the USCIS before your 12 months F1 OPT expires. So then if it is filed with the USCIS, the H1 petition, the student can enjoy the cap gap until the start date of the H1, because as you know, the fiscal year for USCIS starts on October 1st and ends on September 30th. So since the earliest start date of H1B, if the employer files it now in April, May, or June of 2021, the earliest start date is October 1st, 2021. And so the student can enjoy the cap gap protections to be able to legally continue working, even though the OPT expired on sometime, let's say in June of 2021, till September 30th of 2021. And then hopefully on that date, on October 1st, the H1 petition itself with the change of status, meaning the I-94 tear-off card at the bottom of the approval notice is issued by USCIS, approving the change of status from F1 to H1 so that the student can continue to stay legally, work legally, and continue without any hiccup. Before this cap gap protection was introduced, students who, for example, who completed the F1 OPT in June had to either depart the United States and come back by October 1st or 10 days before the start of the H1 petition approval date, or they could stay here, but they weren't even allowed to work legally. And so they were losing income, which can be very stressful for students who already have tens of thousands of dollars in student debt and so many financial problems and tensions to deal with. So it's a wonderful, wonderful benefit that students can take advantage of the F1 cap regulations. However, if, let's say, the employer is unable, let's say the student, the F1 OPT actually expires in April, and the employer doesn't file the new H1 petition until May or June because they got delayed or they didn't realize that the student is F1 OPT is expiring, then if it is filed within the 60 days of grace period after the F1 OPT is completed, the student is allowed to stay in the United States, but is not legally permitted to work during that gap extension, that period from May, June, July, August, September till September 30th, because the person was in a purely in the grace period when the H1 petition was filed and was not maintaining valid F1 OPT with the valid EAD card for working on OPT status.
Got it. Another follow-up question. What happens, let's say they are in the gap and the H1B is still not approved past October 1st? Can they stay in the country?
So again, the student is allowed to legally stay in the United States after October, but is required to stop working unless, of course, the F1 OPT or the STEM OPT was valid well past that date. Even though we had requested October 1st, let's say my status was actually only expiring, the student status in December, then the student can continue till December. But if the status had expired earlier in May, June, July, August, then the student has to stop working, can wait. Some people at that point pay for the premium processing to see if they can get the answer faster. Sometimes we have been seeing over the past 3 or 4 years, particularly, that when the student paid extra money to get the faster decision, that sometimes it ended up with an RFE or even a denial, especially of status issues when students had switched to CPT, F1 curricular practical training, and had tried all kinds of other ways to stay legally in the US because they were not picked in the lottery for 2 or 3 years.
And the last question, what is your advice for students, whose petition is not picked in the lottery and they have already exhausted their F1 OPT or whatever? A lot of people choose for the CPT, day one CPT colleges or the such sort. What's your advice and what's your take on that, and what should actually they do?
So that's a great question. So in general, the USCIS takes the position that F1 CPT is problematic. And so if the student has been using F1 CPT continuously and all trying to figure it out, the USCIS is likely to deny the change of status within the United States for failure to maintain valid non-immigrant F1 status, because they think you're just trying to game the system and work on CPT, when the only time CPT is supposed to be permissible is if it's an integral part of the program, without which you cannot complete your education. Most of the times it is supposed to be unpaid, not all the time, but almost always. So if you are working for money, like it's F1 OPT, or you're working like it's an H1B employment, it is probably not proper, and unless it is an absolute integral requirement, like some MBA programs or very few degrees actually make it absolutely mandatory for the student to work on CPT in order for the student to graduate with the degree itself.
That was, the great explanation. Thanks, Ms. Murthy. Thanks for your time. We are at the end of the show. Thanks for all the calls and watching the show, audience. It's a great session with interesting topics and questions. Please call in every Tuesday at 3 p.m. EST to watch the special immigration show with Ms. Murthy. Again, it's every Tuesday at 3 p.m. EST on Sakshi TV. This is Ranjit signing off. Thanks, Ms. Murthy.
Here's my book again for those interested. 100% of the money from the book, every single dollar goes to charities, to support charities both in the United States and India for very good causes. I know yesterday was International Women's Day. This is the month for women. A lot of it goes to help different charities. So continue. Let's all help each other. And thank you so much for joining us today. Thank you, Ranjit. Stay safe, everybody, and good helping you all. Take care.
Thanks. Bye-bye.